Welcome to another deep dive, everyone. Today we're going to be looking at legislative supremacy in the UK,
Okay.
with a focus on the powers of Parliament.
Sounds good.
Our main source material today is a chapter from a legal textbook,
Yeah.
and it's called 5, The Legislative Supremacy of Parliament.
Interesting.
We don't know the exact book it's from, but this chapter is really fascinating, and I think it'll give us all a lot to think about when it comes to how laws are made.
Yeah, I think so too.
One of the first things that stood out to me was the term legislative supremacy.
Oh, yeah.
They use that instead of the more common parliamentary sovereignty.
I noticed that too.
Do you think they're trying to be really specific with the language there?
I think so.
Yeah.
The chapter talks about how using legislative supremacy helps avoid some of the political baggage that you get with a word like sovereignty.
Right.
But they're both dealing with the same question.
Yeah.
How much power does Parliament actually have to make laws?
And how far does that go?
Ex-
So the source lays out kind of the traditional Dacian view,
Right.
which is that Parliament can make or unmake any law, and no other body can overrule it.
Wow.
That sounds pretty powerful.
Yeah, it's a pretty bold statement.
It is. Does that mean that they could pass any law no matter how crazy it is?
Well, that's where it gets interesting.
Yeah.
The chapter actually uses an example.
Yeah.
It suggests that, in theory, Parliament could pass a law that says all blue-eyed babies should be killed.
Oh, wow.
Yeah, it's a pretty extreme example, but it really emphasizes the potential limitlessness of Parliament's power, at least in theory.
That's a chilling thought.
It's
So then what are the constraints on what Parliament can actually do?
That's where the courts come in.
Okay.
Parliament might make the laws,
Yeah.
but it's the courts that have to uphold and enforce those laws.
Right.
So that's where legislative supremacy actually gets its practical effect.
Okay.
And historically, the courts have tended to obey acts of Parliament pretty consistently.
So there's a pattern of the courts saying, well, Parliament said it, so it must be right.
You could say that.
Interesting.
There are a lot of cases that show this.
Uh-huh.
One that comes to mind is Mad Zimbamudo v. Lardner Burke
I've heard of that one.
from 1969.
Oh, wow. Okay.
This was during a time when Southern Rhodesia, a British colony, was trying to declare independence
Okay.
unilaterally.
Mm-hmm.
The UK Parliament passed a law saying that Southern Rhodesia's declaration was illegal.
A direct clash then.
Exactly. A clash between the colony trying to break away and Parliament asserting its authority.
Wow.
And in this case, Lord Reed, a very important judge, said something that's often quoted.
Oh, really?
He said, if Parliament chose to do any of them, the courts could not hold the act of Parliament invalid.
So basically, Parliament's power is supreme.
Yeah, even in situations that are politically or morally complicated, that's what the courts seem to be saying.
That's really interesting.
It is.
So it sounds like Parliament's had a pretty free hand throughout history.
For the most part,
Yeah.
but there have been challenges
Yeah.
to this idea of absolute power.
What kind of challenges?
Well, for example, there's Lord Wolfe,
Oh.
a former Lord Chief Justice.
Mm.
He suggested that maybe in some extreme cases, courts would be right to disobey a law
Oh, wow.
if it went against the rule of law.
So the idea that there's a higher legal principle than even Parliament?
That's the argument.
Wow.
It comes down to what the rule of law actually is.
Right.
And who gets to decide that?
And who gets to define it?
It's a tough question.
It is a tough question.
But for now,
Yeah.
let's look at how this idea of legislative supremacy became so strong in the UK.
Okay.
The chapter points to the Glorious Revolution of 1688.
Oh, yeah. The Glorious
Now, that's a
Revolution.
really key moment.
That's where things get interesting.
Yeah,
Before 1688, the courts weren't always so quick to just agree with Parliament.
that's right.
So what changed?
Well, the Glorious Revolution,
Yeah.
it was a turning point. It
Mhm.
shifted power away from the monarch and towards Parliament.
And how did that happen?
It all started with King James II.
Okay.
He was Catholic,
Mm.
and he was clashing with Parliament, which was mostly Protestant.
Okay.
He tried to use his royal prerogative to get around laws that discriminated against Catholics.
Oh, so he was trying to bypass Parliament?
Basically.
It became a power struggle.
And who won?
Parliament came out on top.
Of course.
Some powerful politicians basically invited William of Orange,
Okay.
James II's son-in-law, to take over.
Wow.
And William was Protestant.
Right.
And the crazy thing is,
Yeah.
James II just fled to France.
Oh, wow.
So William became king.
Wow.
And this led to the Bill of Rights in 1689,
Yeah.
which basically said that Parliament was supreme.
Over the monarch. So it sounds like a pretty big shift in power.
It was huge.
Wow.
From then on, things like taxes, the military, and of course lawmaking, those were all controlled by Parliament, not the monarch.
Right.
And you can see this in the way the courts started to treat acts of Parliament. Okay, how so?
Well, for example, in the case of XP Ken and Selwyn, the Chief Justice said that no court could say an act of Parliament wasn't valid.
So the courts were acknowledging Parliament's supreme power.
Exactly.
It sounds like the Glorious Revolution really solidified this whole idea of legislative supremacy.
Yeah, it was a turning point.
But even with that firm foundation, there have been challenges, haven't there,
Oh, yeah, definitely.
to that absolute power?
One of the biggest challenges
Yeah.
is the question of entrenchment.
Okay, entrenchment.
So can Parliament actually limit the power of future parliaments?
Okay, so what does entrenchment actually mean in this context?
Think of it like putting extra locks on a door
Okay.
to make it harder to open.
Okay.
Entrenchment means making some laws harder to change than others.
So they're protected.
Yes, protected from being easily altered or repealed.
Got it.
Now, traditionally, the UK Parliament has been seen as unable to do this.
To entrench laws.
Right, because each parliament is supreme.
Right, so one parliament shouldn't be bound by what a previous parliament did.
Exactly.
That makes sense.
But there's another argument called the manner and form argument.
Okay, manner and form.
It challenges this traditional view.
Interesting, how so?
It says that maybe Parliament can't control exactly what future laws say,
Okay.
but they could set the rules for how those laws are made.
So it's not about the what, but the how.
Exactly.
So what kind of rules are we talking about?
Well, for instance, they could say that certain types of legislation need a supermajority vote.
Yeah.
Or they could set specific procedures that have to be followed.
So Parliament can't tell future parliaments what to do, but they can tell them how to do it.
That's the idea.
Interesting. And has that argument been successful anywhere?
It has, actually.
Right.
There are cases from other countries like Australia and South Africa
Okay.
where courts have upheld this manner and form approach.
But those cases aren't from the UK.
You're right. They're not binding in the UK system. But they show us that this alternative way of thinking about legislative supremacy exists. And it has been used successfully in other common law systems.
So it's not impossible that a UK court might consider similar arguments.
That's true.
And actually, speaking of challenges to legislative supremacy,
Yeah.
the chapter also mentions the Parliament Acts
Oh, yes.
of 1911 and 1949.
Those are important ones.
I think so. They actually changed the way some laws are made in the UK.
They did.
Yeah.
The Parliament Act,
Yeah.
especially the one from 1949,
Uh,
they limit the power of the House of Lords.
right. So the House of Commons can sometimes bypass the Lords.
Exactly, under certain conditions.
So Parliament kind of changed its own rule book.
That's one way to look at it.
And then there's the Jackson case,
Right, Jackson?
which directly challenged the law that was passed using this process.
Yeah, the Hunting Act of 2004,
Right.
which banned fox hunting.
Okay.
That act was passed using the procedures set up by the Parliament Acts.
Because the House of Lords was against it.
Exactly.
Wow. So it was a real challenge to the whole process.
It was.
What happened?
Well, the House of Lords,
Yeah.
they upheld both the 1949 Act
Right.
and the Hunting Act.
So the ban on fox hunting stayed in place,
It did, but the Jackson case is interesting because the judges had different opinions.
even though they agreed on the outcome.
Yeah, about what it meant for legislative supremacy.
So even at the highest court, there was debate about how far Parliament's power goes.
There was.
That's fascinating.
It is.
So what were some of those different opinions?
Well, we have Lord Bingham's view,
Okay.
which is more of a traditional view.
What did he have to say?
He basically stuck to that classic Dyson view,
Okay.
saying there's no reason to limit Parliament's ability to amend the Parliament Acts.
So even the rules about changing the rules can be changed.
According to Lord Bingham, yes.
Wow, okay.
He said if Parliament wanted to change the rules, even to extend their own term, they should be able to do that.
Without the House of Lords.
Right.
Okay, so that's a pretty strict interpretation
It is.
of parliamentary supremacy.
Yes.
But there was another view.
Lord Nichols had a slightly different take on it.
Okay, what did he say?
He suggested that there are implicit limits
Oh,
on how the Parliament Acts can be used.
interesting.
Specifically, he said that the rule against extending the life of Parliament also means you can't use the process to get rid of that rule.
So you can't use the process to change the process.
Yeah, that's a good way to put it.
Wow. So even though the 1911 Act doesn't explicitly say that,
Right,
Lord Nichols is saying that restriction is implied?
exactly.
Okay, why is that?
He argued that this is necessary to prevent Parliament from just getting around the limitations of the Parliament Acts.
So we have two different views here.
We do.
One says Parliament can change the rules however they want,
Mm-hmm.
and the other says there are boundaries, even if they're not written down.
Right.
Which view do you find more convincing?
That's a tough one.
It is.
I think both sides have some good points.
Yeah?
What's interesting is that this whole debate,
Yeah.
it shows the tension between the idea of an all-powerful parliament
Right.
and the need for checks and balances to prevent abuse.
Yeah, to make sure that power isn't being misused.
Exactly. And we see this tension playing out in the Jackson case.
Yeah, just in that one case, we see these different opinions about how far Parliament's power should go.
And this tension becomes even more complicated when we bring in things like EU law devolution and the Human Rights Act.
Right, because those all add layers to the question of who has the final say.
Exactly. They make us ask when different sources of law clash.
Yeah.
Which one wins? EU law is a good place to start.
Oh, yeah. EU law really shook things up.
It did.
When it comes to that traditional idea of legislative supremacy.
It challenged the idea that Parliament always has the final say.
Yeah, and the factor tame case is a perfect example.
Secretary.
It's a landmark ruling where the UK courts actually set aside UK law to comply with EU law.
Yeah, that was a big one.
That seems like a pretty big deal for a country that's so proud of its parliamentary sovereignty.
It was a major moment. It raised all sorts of questions about where the ultimate legal authority really lies.
So did Parliament basically agree to limit its own power?
When they joined the European community,
Yeah.
that's one way to look at it.
Okay.
In the factor tame case, Lord Bridge said that Parliament had voluntarily accepted this limitation on its sovereignty.
When they passed the European Communities Act of 1972.
Right.
So by joining the EU, they knew they were giving up some of their power.
To some extent, yes.
This must have been controversial.
Oh, it was a huge debate.
Yeah.
Legal scholars were divided on what it meant.
Oh, really?
Some people saw factor tame as a constitutional revolution,
Wow.
like a fundamental shift in power.
Yeah.
Others said, no, the courts were just following the rules,
Okay.
the rules that Parliament had set up.
Interesting.
It all comes down to how you interpret Section 2, subsection 4.
Of the European Communities Act of 1972. So some saw it as a radical change, and others saw it as just business as usual.
Right.
Either way, it's clear that EU membership really complicated the whole idea of legislative supremacy.
It added a whole new layer of complexity.
Yeah, and on top of that, we have devolution to think about.
Right, devolution.
Where powers transferred from the UK Parliament to national assemblies.
In Scotland, Wales, and Northern Ireland.
Does that create challenges for the idea of parliamentary supremacy?
It does. It raises questions about where the ultimate power resides.
Yeah, because now you have these other bodies making laws.
Exactly.
So how does that work?
Well, the source material is clear that these devolved legislatures, they can make laws, but only in their specific areas.
Okay.
The UK Parliament still has the supreme power.
So they can overrule the devolved parliament.
If they need to, yes.
So it's like a parent and a child.
That's a good analogy.
The parent gives the child some responsibility, but they still have the ultimate authority. The source even cites specific sections.
From the relevant acts.
Like the Scotland Act of 1998.
Yes.
It says that the UK Parliament can still make laws for Scotland.
Even on matters that have been devolved.
So there's no doubt about it, the UK Parliament is still at the top.
Legally speaking, yes.
And have there been cases that have confirmed this?
One that comes to mind is Whalley v. Lord Watson of Invergory.
Okay.
A Scottish judge in that case emphasized that the Scottish Parliament, it gets its powers from the UK Parliament.
So it's subordinate.
Yes. Ultimately, it's subject to UK law.
So devolution changed the political landscape.
It did.
But it didn't fundamentally change the principle of parliamentary supremacy.
That's a good observation.
Interesting.
Now let's move on to another big piece of this puzzle.
Okay.
The Human Rights Act of 1998.
The Human Rights Act. This is a big one.
It brings the European Convention on Human Rights into UK law.
And it raises a lot of questions about how it fits with this idea of Parliament being supreme.
Definitely, because it introduces all these rights and principles.
That could potentially conflict with the idea that Parliament can do whatever it wants.
Exactly.
So can Parliament pass a law that violates human rights?
That's one of the big questions.
Yeah.
And if they do, can the courts do anything about it?
It seems like the Human Rights Act could really limit what Parliament can do.
Well, it's not quite that simple.
Okay.
One important thing to remember is that the Human Rights Act itself is not entrenched.
Okay, so Parliament can change it.
Just like any other act.
It's not set in stone.
Right.
Okay. But the chapter also says that even though it's not technically entrenched, it might be harder to change in practice.
Because of its symbolic significance?
It's like it has a special status.
You could say that.
So it might be politically difficult for Parliament to mess with it.
That's the argument.
That's interesting. So even without formal legal mechanisms, political and social norms can limit Parliament's power.
That seems to be the case.
So let's get into the specifics of the Human Rights Act.
Okay.
How does it actually work?
The chapter focuses on two key provisions.
Okay.
Sections 3 and 4.
Right, sections 3 and 4.
Those are the ones that deal with the potential conflict
Yeah.
between Parliament's power and human rights.
So what does Section 3 say?
Section 3 is about interpretation.
Okay.
It basically says that courts have to interpret laws in a way that's compatible with the European Convention on Human Rights.
So they have to try to make existing laws work with human rights,
Yes, whenever possible.
even if those laws were written before the Human Rights Act.
Right.
So the courts are doing some mental gymnastics here.
They're trying to find ways to make things fit.
Yeah.
But what happens when a law just can't be reconciled with the convention?
No matter how hard you try to interpret it.
That's where Section 4 comes in.
Okay, what does that say?
Section 4 says that the courts can issue what's called a declaration of incompatibility.
Okay, a declaration of incompatibility.
Okay. If they find that a law can't be interpreted in line with the convention,
It's like they're sending a message to Parliament.
yeah, like, hey, this law needs to be fixed.
Because it violates human rights.
Exactly.
But does a declaration of incompatibility actually invalidate the law?
It doesn't.
Oh, it does. No.
It puts pressure on Parliament to do something,
Yeah.
but it doesn't force them legally.
So it's a strong signal, but it still respects parliamentary sovereignty.
Yes. The final decision still rests with Parliament.
So the Human Rights Act balances human rights with Parliament's authority.
That's a good way to put it.
And the chapter gives us some real-world examples.
Of how this all plays out in practice.
Yeah, let's get into some of those cases.
Okay, let's start with R.V. Offen.
R.V. Offen, okay.
This case was about a law that required mandatory life sentences.
For certain repeat offenders?
Yes, and this law raised concerns about whether it was compatible
With the Convention's right to liberty
Exactly.
and security of person. So the courts had to decide if this mandatory sentencing scheme could work with the Convention.
They did, and in this case,
Yeah.
the Court of Appeals said that the law could be compatible
Okay.
if it was interpreted narrowly,
Yeah.
focusing only on cases where the offender was really dangerous.
So they basically limited the scope of the law
Yes, they read down the law.
to make it fit with human rights.
Exactly.
That's clever.
It's a good example of how Section 3 can be used
Yeah.
to bring laws in line with human rights.
Without actually changing the law itself.
Right.
But there are also cases
Or that's just not possible.
where you can't interpret your way out of a conflict.
Right. The law and the convention just clash too much.
And then what's
One example is RVA, No. 2.
RVA? Okay.
This case was about sexual history evidence in a rape trial.
Oh, wow. That's a really sensitive issue.
It is.
How did the Human Rights Act come into play there?
The case was about whether evidence of the complainant's past sexual history
Okay.
could be used in court. The existing law restricted the use of this kind of evidence.
Okay.
But the defendant said that this violated his right to a fair trial.
Under the Convention.
Right.
So what happened?
Lord Stein, who was one of the judges in the House of Lords,
Yeah.
he said that courts could actually imply provisions into a law
Wow.
to make it compatible with the convention.
So he's saying the courts can basically rewrite the law
In a way.
and make it comply with human rights.
That's the idea.
Was everyone on board with that?
Not quite.
Okay.
Another judge, Lord Hope, agreed with the outcome of the case, but he was worried about this approach.
Okay.
He said it was like judicial vandalism.
Judicial vandalism. Wow.
He thought judges shouldn't be acting like legislators.
Yeah, it's overstepping their bounds.
That's his argument.
So there's a fine line between interpreting the law and actually creating new law.
There is.
And this debate comes up a lot.
When you're dealing with the Human Rights Act,
Yeah.
another good example is Gaidan v. Godin Mendoza.
Gaidan v. Godin Mendoza.
That case was about same-sex partners and inheritance rights.
Right.
Whether a same-sex partner could inherit a tenancy
At that time, same-sex partnerships weren't recognized in the same way.
as heterosexual marriages.
Right.
The law only gave inheritance rights to spouses.
So how do they apply that to a same-sex couple?
without violating their human rights.
That's a tough one.
It was a landmark ruling.
Yeah.
The House of Lords said that the word spouse should be interpreted more broadly.
To include same-sex partners.
Yes.
So they stretched the meaning of the word.
To make the law work.
And to protect human rights.
Right.
But I'm sure some people weren't happy about that.
There were some dissenting opinions.
Yeah.
Lord Millett.
He
agreed with the outcome, but he thought this was going too far.
In terms of interpretation.
Yes, he thought it was straying too far from what Parliament intended.
So it's a delicate balance.
It is.
Trying to be true to the law, but also making sure it doesn't violate human rights.
And sometimes that balance is impossible.
Right.
Sometimes the conflict is just too big.
And you can't interpret your way out of it.
Right.
And that's when the courts use Section 4.
And issue a declaration of incompatibility.
Right, so it's the last resort.
It's a way of saying, Parliament, you need to fix this.
This law needs to be changed.
Yes.
The chapter mentions that there have been quite a few of these declarations.
27 by 2011.
Wow, so it's not a theoretical issue?
No, it's a real tension.
Between Parliament's power and human rights.
And the courts are right in the middle of it.
So we have this idea of Parliament being supreme,
Mm-hmm.
but then we have human rights norms that are pushing back against that.
It's a fascinating dynamic.
It is.
The Human Rights Act doesn't really resolve this tension.
Okay.
It sets up these mechanisms
It's not like interpretation.
and declarations of incompatibility.
Right.
But it doesn't definitively answer the question of who has the ultimate power.
So the big questions are still on the table.
They are.
Can Parliament pass a law that violates human rights?
That's a big one.
And if they do, what can citizens do about it?
Those are the questions we're still grappling with.
And to make things even more complicated,
Yeah.
there's the question of the Human Rights Act's retrospective effect. What does that mean?
It means whether the act can be used to challenge laws that were passed before the act came into force.
Oh, wow. So we're not just talking about current laws.
Yeah, we're talking about past laws, too.
Whether they can be challenged based on human rights.
Exactly.
Wow, that opens up a whole new can of worms.
That it does.
It's not just about the present and the future.
Right.
Now we're talking about the past, too.
And whether the Human Rights Act can be used to reevaluate past decisions.
It's like looking back through a new lens.
A human rights lens.
And I bet this has caused a lot of debate.
It has. It's a very controversial issue.
So we're going even further back now, not just if the current laws are compatible with human rights, but if past laws can be challenged, too.
Yeah, it gets complicated.
It sounds like this question of the Human Rights Act's retrospective effect has kept the courts pretty busy.
It has. The chapter mentions a couple of cases, Lambert and Cansall, I know two,
Okay.
where the House of Lords actually reached different conclusions on this very issue.
So even at the highest court, there was disagreement about whether the act could be applied retroactively.
Yeah, it was a split decision.
That doesn't make things very clear, does it?
No, but it highlights the complexity of this issue.
Okay.
The chapter does point out that later cases like Aston Cantlow, Wilson, and Ree McCurr,
Yeah.
they seem to be leaning towards the view that the act is generally not retrospective.
So maybe some consensus is starting to form.
Maybe.
But then there's that case, Rima Coffey's application for judicial review,
Right.
where the Supreme Court made an exception.
It seems like every time we think we've got a handle on this, there's another twist.
It does. What happened in that case?
That case involved Article 2 of the European Convention on Human Rights.
The right to life.
Yes, the right to a proper investigation. And the court decided that even though the events happened before the Human Rights Act came into effect, the state still had to make sure the investigation met the standards of the convention.
So even though the act wasn't in effect at the time,
Right.
it still had an impact on how the investigation had to be conducted.
Exactly.
That's pretty significant.
It shows that the question of the act's retrospective effect is not simple.
Right. It's not a yes or no answer.
There are some areas, especially when it comes to really fundamental rights,
Like the right to life?
yes, where the courts have applied convention principles to past events.
Even if the act wasn't technically in force at the time?
Exactly. It's a nuanced issue,
It sounds like the courts are still figuring out the limits of the act.
especially when dealing with things that happened before it existed.
It's a reminder that law isn't always black and white.
It's not. It's fully gray areas.
And interpretation.
Definitely.
This has been a really fascinating deep dive.
I agree.
We've covered so much.
We have.
From the history of legislative supremacy to the challenges of EU law devolution and the Human Rights Act.
It's a complex topic.
It is. And it seems like this principle of legislative supremacy, it's really important to the UK Constitution, But it's not simple or fixed.
It's always evolving.
It's constantly being tested and reinterpreted.
As new things happen and society changes.
And I think that's a key takeaway for our listeners.
Definitely.
The UK Constitution is not a static document.
It's a living thing.
It changes over time.
It adapts.
It responds to new situations.
New ideas.
And the debate about who really has the final say.
Parliament or the courts?
That's a debate that will probably never end.
Probably not.
The chapter ends with a really interesting question about the Human Rights Act.
Oh, yeah.
It says that even though the act itself isn't entrenched, it might be harder to change in practice.
Because of its symbolic importance and the political fallout that could come from weakening it.
So the question is, do you think that's true?
That's a tough one.
And what does it tell us about the power of those non-legal limits on Parliament's authority?
That's a really good question to think about.
Yeah, it makes you think about how political and social forces shape the way law actually works.
Even in a system where Parliament is supposed to be supreme.
It suggests that the limits on Parliament's power aren't just found in legal documents.
Right. They also come from the values and beliefs of society.
It's a reminder that law isn't just about rules.
It's about people.
And it's about the ongoing conversation between those in power and the people they govern.
And we all have a role to play in that conversation.
Exactly. Well, thank you for joining us on this deep dive into legislative supremacy in the UK.
It's been a pleasure.
I hope you found it informative and maybe even a little bit inspiring.
I hope so too.
If this topic has sparked your interest, I encourage you to keep exploring.
There's always more to learn.
There's a whole world of legal scholarship out there waiting to be discovered.
Happy reading.
Thanks for listening, everyone.